Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
I object.
This is the next search on February 28, 2020, 7:44 p.m. How, does the FBI find people? The people's misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
It's really dark in here. Somebody needs to turn on the lights. Welcome back to the Court of Public Opinion. I'm the Recovery Addict. Just trying to get everything put back in place today here. And then let's turn the lights on, shall we? It's a little better. It's a little better. Tiny bit grainy. The gain's a little too high right now, but we'll work with what we've got right here. Welcome. Good to have you here. We're about to kick off what is going to be the second part of this amazing hearing today about death penalty for Bryan Kohberger. There we go. All right, here we are. We're about to go back to court. They should be back here in just a moment as they're restarting for the afternoon. We have a few more items to discuss on the agenda, but all of them pretty much have to do with the death penalty in one way or another. In that they're trying, they being the defense, are trying to keep Bryan Kohberger from facing the death penalty. If they can win this argument here, then it's not a possibility later. And, the whole ounce of prevention is worth a pound of cure. They're trying to prevent death penalty from being an option. So far, we have heard a motion on, the street clothing in public hearings. The state did not object. He's going to be wearing a suit and tie to hearings up till the trial and during the trial as well. Then we heard the objection from the state about the testimony of Barbara Wolf. The state won that one. Barbara Wolf was not heard. We heard a motion about the method of execution, meaning Idaho doesn't have the ability to execute because lethal is the chemicals are not available. Firing squad, they don't even have the unit built. That was heard, and the judge is going to issue a written ruling later, but probably not in the favor of the defense. Next, we heard the professor Cover, who wanted to share a little bit of information about the death penalty and her study and analysis of that. And the judge said, I'll pass on that. Thank you. If I want her opinion, I'll call you back. My sound is really choppy. Test, check 1, 2. Is it choppy for anybody else? Let's see. Let me know. Not for me. Refresh your screen. Sounds good. All right. So Professor Cover is out on the issue of arbitrariness. Let's see if I can put this on my window so I can see it. Box source 4 will be 3. There we go. On the issue of arbitrariness, the judge has heard the evidence, has heard the arguments on both sides, and is going to issue a ruling at a later point. But the way he asked questions, it doesn't sound like he's leaning towards the defense on that one either. We've got a motion to strike statutory aggravators that didn't go over very well with the judge. The argument was quite weak. Also, he's going to issue a written ruling on that one. We've got the motion, proof of non-statutory aggravators. On this one, the state's like, I don't even know what they're talking about, Your Honor. What non-statutory aggravators they think we're going to bring up as evidence seems weird. The judge is like, yeah, the standard rules of evidence, you follow that. I'll make the rules. It's just going to be a trial as normal. So I think that's a nothing burger right there. Let's see. We have remaining the standards of decency. Okay. The motion to strike the death penalty because of the standards of decency. The lack of grand jury in the case and international law And lastly, we're going to have a motion to trifurcate or divide into three pieces the proceedings and apply evidentiary rules. Well, evidentiary rules are applied, but dividing that up into three pieces, we'll see about that. So where we stand right now, we have 1, 2, 3, 4 different parts, and most of them are going to be argued by the new attorney who walked in at the last minute and sort of took a seat next to Bryan Kohberger. He's going to introduce himself here shortly. My studio is dark because I have just barely got the cable today, like I connected it during our live stream, to get it set up. Let's see. Let's lift a little bit. That's too many. That's the blacks. We don't want to lift the blacks. Keep the blacks black and the gamma. Let's see if we can do that a little bit. To blue. Filters. I have filters.
Because he's the guy.
I'm going to change the shutter. It's going to... Is that better? It's not in focus now. I like the camera, but it's extremely manual is how I have to set it up. So a little more saturation. Let's crank that up a tiny bit. Go with the mix. Tint. We'll keep tint as 0. Anyway, now I broke it and I have to reset it. Okay, court's going to resume shortly. It's just going to begin as soon as the judge walks in, and we're going to hear these arguments. He said it would be at 2 o'clock, and it's 3 o'clock. Wait. Did he say we get an hour? Do we get an extra hour for lunch? Can somebody go back and see if I'm an hour off on this one? Did he give us a 2-hour lunch? Because this could be a long wait. Meanwhile, I'm still working on my lighting. How's this? Is that okay? Looks good. Siri says it's 1 p.m. there. Yeah, I'm just trying to figure out, were they starting at 1 p.m.? He said 1. He said 1 hour. Okay. Well, we'll just be waiting here for the judge to come back. It's the best I've seen all day. Oh, I'll save it like this then, if you approve. I'm just going to go ahead and lock it down. Okay. And then I'm going to save the startup state, so it's always going to remember that. Hey, we're back. That's good to know. Judge is walking in.
You can be seated. All right, we are reconvened in the matter of State versus Kohberger. Defendant is present together with counsel. I would note for the record that Mr. Lodson is present as well. At this point, the state is present through its attorneys. I think next we started those categories that I identified as the 9th topic. We'll continue with those and then circle back to the 8th. So let's talk about the state's concern about the grand jury not having considered the aggravating factors.
Cheryl C. won the internet this afternoon. Congratulations, Cheryl. It's all yours.
Mr. Logson?
Thank you, Your Honor. I apologize for not being able to be here earlier for proceedings, Judge. I overbooked myself today.
You're here, so that's fine.
Your Honor, as to the argument as to including the statutory eligibility requirements for a death case in the grand jury, I think the two major hurdles that we have to get over are, one, the Hurtado case not requiring the grand jury to apply to the states. And then the second is the ruling in Abdullah that essentially said you don't need to provide these to the grand jury.
Seemed like a good place to start.
It is a good place to start. And as we tend to do in these cases, because they are going to go up on appeal, we are, of course, asking that those things be overruled. Certainly recognize Your Honor doesn't have the ability to do that, but we respectfully make the argument that those cases were wrong. We also make the argument that there is another way to get there. So the Fifth Amendment obviously is the grand jury amendment, and I think Abdullah was looking at the Sixth Amendment or notice requirements and what needed to be included there. We furnish an additional argument that the Eighth Amendment in death cases requires additional process. And we see that largely in what occurs at the sentencing hearing, but we also see it in things like requiring counsel before it was required for anything else was required in death cases. We also see it in requiring the state of Alabama to permit a lesser included instruction so that a jury can choose something besides something that would lead to death.
Let me ask you a question about that. So on the one hand, as I understand your argument, it is that the grand jury should be required to not only find an aggravating, statutory aggravating factor, but also that the grand jury then weigh it against mitigating evidence. Is that your position?
No. Let me be clear. As we would talk about in the trifurcation motion, I'm only talking about the statutory aggravators, not the non-statutory aggravators or the mitigators. It would simply be...
Your brief says otherwise, so that's why I question that, because as we've learned, that takes a long time for those things to be developed. That's not necessarily evidence in the pocket of the state. What is now gone from a case timeline of several months to now multiple years would seem to me to even drag it out longer.
And I certainly understand that concern. I don't think that that's our position. I certainly do believe that the law would require the state to put on mitigating evidence if it had it, because that's something that they're required to do by law. They're required to put on evidence, if known to them, would possibly point in the direction that the person is innocent, et cetera. But I don't think what our position is that the state would be required to put on essentially their entire sentencing hearing in front of that grand jury. The grand jury is still only determining whether or not there is a reason to go forward with the case. Our point is that at the time of the founding, that grand jury would have known that all felonies lead to the gallows. So at that time, the grand juries were making decisions about whether or not people were going to face the death penalty. And it wasn't until the Supreme Court after Furman in the 70s that we came up with this entirely new system, but it's one where the grand jury has lost its part of its function, where it's looking at whether or not these people should be facing the death penalty or not. Essentially, they were deprived of that through the transition that was obviously intended to protect people from an arbitrary infliction of the death penalty. But the grand jury itself is supposed to also have a role in that. It's supposed to protect people from arbitrary decisions. And so that's essentially what our argument is that there should be a neutral fact finder placed between the citizen and the state when we're making the decision whether or not the death penalty should be sought. And so that is one of the reasons we're asking the court to strike the death penalty in this case. Does the court have any other questions for me? Thank you, Judge.
His heart isn't in that argument. He knows the judge can't do that. He's doing this to preserve for appeal up higher.
Your Honor, sounds like on Abdullah, this is just a issue of issue preservation, so I don't have much to comment on that. In terms of this other argument that they are saying you can look at it differently through the Eighth Amendment, keep in mind the Eighth Amendment is just the prohibition on cruel and unusual punishment. It's quite a stretch to jump from there to requirements on what needs to be presented to a grand jury. The Beck case that they cited suggests that maybe there could be a connection if that diminishes the reliability of the sentencing determination or the guilt determination, but that's not the function the grand jury plays. And so for this court to stretch the Eighth Amendment all the way back to the grand jury would be...
In fact, with respect to failings of a grand jury to pass on a particular element, for example, if there's then been a trial, the general standard of appeal is, well, the matter went to a jury and they made the determination there's proof beyond a reasonable doubt, and therefore any error is moot.
Correct, Your Honor. And I think really that gets to the heart of this claim, which is it's just kind of another way of their argument that it shouldn't be the prosecutor deciding that a notice is filed. And the U.S. Supreme Court has said it's not a problem if the prosecutor has unfettered discretion in who gets the death notice and who doesn't. So that by itself isn't a problem. So unless there are any other questions, thank you, Your Honor.
Thank you. Any rebuttal?
Well, I think it would be best to push back at least a little on the idea that the Eighth Amendment can't go back that far. I mean, recall that it was the Eighth Amendment that required that there be counsel for people that were facing the death penalty. Now, I certainly understand the idea that the Eighth Amendment's concern is that we have a reliable procedure. I certainly understand that. But the grand jury, it does fulfill some of that function as well. And besides, at least if we're speaking in terms of what was understood to have a grand jury and what it did at the time that the nation was founded, it would have been stepping in a case involving a possible death penalty and being able to put a stop to it then and there. And so I do think that the Eighth Amendment has the ability to attach even that early on, at least in cases involving death. And then I recognize that there are these cases from the Supreme Court indicating that prosecutors do not have to have anybody determine whether or not they can file the death penalty and that they can drop it out of a sense of mercy. I think that's a slightly side question to, if they choose to go forward with it, who can stand up and say, before we spend years on one of these cases, that this is not the appropriate case, someone besides the prosecutor, which is what we have with grand juries and preliminary hearings, et cetera. And so we still believe that the argument here is one that can be passed on by this court and that hasn't necessarily been ruled on by these other cases that we also think should be overturned. Thank you, Judge.
Thank you.
He just doesn't sound like
I believe I have all the remaining arguments, so whichever the court would like to.
Let's finish up topic 9 with your contention that the death penalty should be struck because it violates international law.
Thank you, Your
The
Honor.
judge is trying not to smile.
So
through this
that
one.
motion is largely premised on the International Convent of, I'm going to have to pull it up because it's the ICCPR.
He was not ready. That's the crux of the whole argument, and he doesn't remember what it is.
International Covenant on Civil and Political Rights. And so essentially the argument comes down to this. We have signed and ratified a treaty that would put, we think, additional requirements on what we would do if we're going to have a death penalty in this country, and obviously we have one. One of those is a requirement that we make sure that we're not arbitrarily killing people. And the other one is that people are not being essentially tortured.
My understanding is when the time that that convention was ratified with the understanding that to the extent that it is agreeing to anything, it is agreeing to afford the Eighth Amendment protections.
That's correct, Judge. And I think to some extent, what we're arguing is the Eighth Amendment and the ICCPR work together, and that we can look at these international obligations and the Eighth Amendment and say that for them, they essentially are the same thing. That's why we talk about.
Well, I think you're looking at it from two different prisms. I think what the state is saying, to the extent that this covenant applies, which is questioned about whether it's self-executing and all the rest, it only governs to the extent that the Eighth Amendment, apart from that, would have protected that situation. Whereas what I think you're arguing is that the Eighth Amendment must be read to be broader as to what international law would dictate.
I think if what we're saying is that the state would argue that we read the Eighth Amendment and that's what the international law must be, we're saying you have to read the international law to decide what the Eighth Amendment.
So you're having the international law dictate what the United States Constitution means.
Yeah, that's not going to go over.
Correct. And we are doing that on the basis of what the United States has said itself about the fact that they believe that they live up to these things, and the fact that we have, we discussed the charming Betsy canon, which is obviously a very old canon and typically is just about whether or not our statutes are in line with our treaties. But I think particularly in this case, where the United States has essentially said, we signed on to this treaty because we live up by these same standards that everyone else does, we can look at what the international community thinks about those standards that we said we also abide by when we're determining whether or not we're living up to the standards in the Constitution.
But what they said specifically is that we think that we are living up to those, even though we have and will enforce a death penalty.
And I think, which is why we're not saying necessarily that the death penalty would be struck if it was done properly. Our argument is that the way that Idaho has its scheme set up, there are far too many statutory aggravators, and some of them are just big enough to drive a Mack truck through. And so just about every murder could be charged and have the death penalty attached.
Mack truck reference.
And so that doesn't require the narrowing that we've said we're going to provide, and it certainly doesn't live up to what the international community would expect from us.
Yeah, I understand the argument.
Well,
I'll be frank, it's falling about as flat as you would expect it to fall before our Supreme Court or the Supreme Court of the United States.
Well, you're all right. It's an argument, and it must be made. So
it must be made.
We need to make a record.
Thank you, Judge.
Are you done? The state says, yeah. We're just going to sit down and just let that one just fizzle out.
Unless the court has any questions, I'm okay.
Yeah, nothing from the state. They knew there was no
All right, let's talk about
merit to that at all.
The contemporary standards of decency.
Thank you, Your Honor. So I think the main case for this one was Roper v. Simmons. Unless I'm confusing it with Atkins. But essentially the court has said that when deciding what contemporary standards are in terms of what's cruel and unusual, that the court first looks at what the state legislatures are doing and then makes a decision based on its own determination of what it is it's going to be. But when we look at those cases, they also look at other things. They look at international law. They look at what religious organizations are saying. I mean, they're obviously looking for what's the consensus going on.
I think Idaho Supreme Court said is what we look at is legislative and governmental determinations and actions.
That I think that's Abdullah where they had said that, and I think that was partly because the way that it was. And in those cases, it seemed like the record that was brought up to them was somewhat sparse. And so hopefully we've provided more information than they had at those times. But in those cases, the number of states that still allowed the death penalty, I think, was around 35. And as the court, as we noted, that number has dropped somewhat precipitously since that time.
And those would be the legislative activities. I think what I was, I guess, taking issue with is the idea that they would look to what religious and other sort of non-governmental advocacy groups would argue or accept.
Well, I can only say that Roper
this is their closer.
Definitely looked at international law. And if it wasn't Roper, then it was Atkins. But the one about children and whether or not they can face the death penalty, they definitely looked to international law. And so I don't think there's anything that says that the court can't look at whether or not organizations have moved against the death penalty. We are becoming somewhat alone in the world in terms of continuing to make use of the practice. The number of states that are still doing it is shrinking. And so when you look at that total fabric, it's our contention that we've reached the point where the death penalty really ought to be abolished. And so that is our contention in this case. Thank you, Judge.
This is not a closing hitter. This is not the guy you bring up when you have bases loaded.
Thank you, Your Honor. While Roper may have looked at some international law, I think the Idaho Supreme Court has really narrowed that window. First in Abdullah, they said, therefore, absent some legislative or executive action, a determination by this court that Idaho's death penalty statute is unconstitutional based on evolving standards of decency and public opinion is unsupported. So they're really looking in at that. And fast forward 5 years in the Hurston decision, 2020, the Idaho Supreme Court reaffirmed that view and then also said, quote, we continue to subscribe to the view of legislative bodies as the basis for determining a national consensus. And so, and the reason for that, they explain in Abdullah, is that courts just aren't good at taking a temperature of public opinion and what represents society's views. Now, looking at the states that have capital punishment, according to the resources both sides have cited, there's 27 states that still have it on the books. That's a majority. They've pointed out that there's gubernatorial moratoriums in 6 of those, which is true. But that means worst case scenario, there's 21 states that still have the death penalty on the books and can use it. And what the Idaho Supreme Court said in Hurston is that we're looking for a national consensus. And we're nowhere near a national consensus that the death penalty is somehow immoral or improper or indecent. I would also just note, it's not enough if what you're trying to show is a national consensus. It is not enough to just point to the fact that a state doesn't have the death penalty. You would have to show that the state removed the death penalty because that state believed that it was immoral or improper. So, for example, if a fiscally conservative legislature just decides they don't want to fund the death penalty, but they have no moral objection to it, that's not evidence that there's some societal standard that would.
What do you take of evidence from a state who is not enforcing the penalty because, for example, an executive of that state is morally opposed to it and has the power to preclude it from being applied? Should that be considered?
So the Idaho Supreme Court did mention executive action, although in Hurston they seem to say the better picture is painted by legislative bodies. And I think part of the reason for that is because the executive, it can just depend on the administration that's in power at that moment. A perfect example of that is the United States. The death penalty is on the books. It's currently not being applied, but shortly before the current administration it was. And I think it's safe to assume that it will be again here shortly. The other thing you have to look at is, why is the executive doing this? For example, the defense cites that Tennessee has currently a moratorium. True, but the governor did that because he said we need to take time to fix the execution protocol. That's not evidence of a national standard that the death penalty is wrong.
So in a state like Tennessee, are they still in the sentencing capital sentences, but just not carrying them out, or have they stopped even trying capital cases?
I can't answer that definitively for Tennessee. My understanding is that they still try them and impose the death sentence, but that it's just not being carried out. I know that to be true, for example, in California. Juries are still imposing the death penalty. I know in Ohio, another state that they've pointed to where there's a gubernatorial moratorium, there are 30 scheduled executions in that state. They keep getting pushed back, but the reason they're getting pushed back and the reason for the moratorium is they can't find chemicals to do lethal injection. Again, that's not evidence that there's some standard of decency that's keeping them from doing this. They just can't find the chemicals to do it. So I think...
Well, I mean, you could imply that the standards of decency as applied by the pharmaceutical companies who refuse to take part in it is some measure of that.
Potentially, yes. But I think, again, going back to the Idaho Supreme Court's decisions, we're looking specifically at executive and legislative action. And the fact that the legislature or governor is saying we would do this, but we can't get the chemicals, is actually evidence that they still support the death penalty. So I think no matter how you read the numbers, we're not at a place where there is a national consensus that the death penalty is indecent. And so we think the court should continue to follow what the Idaho Supreme Court said in both Abdullah and Hairston and reject their motion. Thank you, Your Honor.
All right, there's international law. We got the standards of decency.
Just briefly, Judge, I would caution the court trying to figure out why it is that a particular state either dropped the death penalty or imposed a gubernatorial moratorium. I mean, I think
those two words together are fun.
These things are complicated. That looks an awful lot like trying to figure out from legislative history why something occurred. Half the time, what you see in the questions doesn't necessarily tell you what the legislature had in mind when they finally voted. And so I think the first step, as the United States Supreme Court has set it out, is just to look at the numbers. And then after that, the courts can consider other things.
There are 20, 21 if you take into account moratoriums. How, I mean, certainly more than a third of the states, how does that represent a consensus?
I would argue that the consensus can also come from the trajectory. So the fact that so many states dropped the death penalty within the last 10 years, and that appears to be the direction that things are going, is something that the court can take into account. I also note a lot of these states that have death rows and don't have a moratorium still aren't actually executing anyone. And so the actual number of executions in the states that are actually executing anybody is less even than that. I think it's something like 13 jurisdictions that are actually doing executions. So anyway, for those reasons, Your Honor, we are asking that you strike the death penalty.
Thank you. All right. I think that leaves us with your motion to trifurcate the proceedings and to apply the rules of evidence in the penalty phase.
Right. So, Your Honor, I tried a case via the trifurcated method. It went smoothly, and we moved this court to do the same thing. If it's not trifurcated.
Which case was that?
That was Renfro.
Which one?
Renfro. If it's not trifurcated, what happens at in the penalty phase is the state would be putting on both statutory aggravators and non-statutory aggravators. I think the states argued that some of those things.
Isn't there a post-conviction proceeding in which it's alleged that that is ineffective assistance to allow the trifurcation because you make the jury decide about whether or not an aggravating factor is there in the absence of any mitigating evidence that might otherwise affect their decision?
I'm sure there is. But I can't say that I agree. Because from a jury's perspective, I mean, you have to realize that these are people who have been pulled in, they don't have legal training, and now you're asking them to make a bunch of different decisions at the same time. And as we pointed out, I mean, we can go back and forth about, what's the, if you don't trifurcate, you're going to put on the victim impact during the penalty phase. with everything else, right? And so whether or not there's even a statutory aggravator is now going to be influenced by all of the things that are emotionally really powerful. And so, I mean, we can go back and forth about, who does that prejudice. At the end of the day, a trifurcated proceeding is just simpler for a jury to do their job. They have to be able to make a decision about statutory aggravators to even have a death penalty in a particular case. Being able to do that with just a standalone, do these things actually exist first before you start to get into the mitigating and aggravating? I mean, you can put on some mitigating depending on what the aggravator is at the aggravating portion of the case. You can talk about future dangerousness and things like that, assuming that the court decides to let it in. But if you don't do it this way, what you risk is that a jury is going to be influenced by non-statutory aggravators, victim impact statements, and on those grounds, say yes to one of the statutory aggravators. And you also are telling the jury, these things you have to find beyond reasonable doubt, but these things you don't, and do all of that at the same time. And I mean, the studies have shown that juries really want to get these things right, and they really want to follow the law, but oftentimes the instructions that they get aren't really that clear. And I think adding to their burden by cramming it all into one hearing, it's unnecessary. The court has the ability, I think under Rule of Evidence 106, to let them do the function that they're supposed to do with the statutory aggravators, and then that way they can make that decision. And if they don't find any, you don't even have to do the next part. But if they find one, then you open it up into the state's case in aggravation and the defense case in mitigation. In terms of using the rules of evidence, as we pointed out, a number of courts have said, confrontation clearly needs to be able to apply. You have discovery that needs to go out. Rules of evidence are helpful, and they're certainly helpful when you're talking about the statutory aggravators themselves. I mean, that's an area where if you're trying to make a accurate determination of whether or not those things exist such that you can have the death penalty, the use of the rules of evidence is, I think, can be detrimental to both sides if you just kind of allow willy-nilly whatever to come in. So
they go on willy-nilly.
And for the other reasons we put in the brief, Judge, we are asking the court to consider doing this as a trifurcated trial if it gets there. Thank you.
I want to hear what the state says on this one, because this, I think, is a discretionary matter for the judge.
And Your Honor, just to briefly address the point about the confrontation clause and the rules of evidence. The defendant has fairly acknowledged in his brief that the Idaho appellate courts have issued binding precedent that's contrary to their argument today. The state's not going to belabor that point. I think the case law is clear, and the state briefed that. As to trifurcation, the defense has yet to lay out what exactly this process would look like. And what I mean by that is, at what point it appears, although the defense has not explicitly stated this, that they would encourage this court to adopt a procedure where the state puts on all of its aggravating evidence for all of these statutory factors, and the jury then goes to deliberate on these factors without hearing any of the mitigating evidence. Now, this is very concerning, and particularly, the state briefed this. You take the propensity aggravator, where the jury is tasked with determining whether or not the defendant's going to pose a continuing risk, to send them back to deliberate without allowing them to hear evidence in mitigation. That's very concerning to the state about what that might do to, for example, the appellate record. And I think that post-conviction proceeding in the Renfro case really highlights the concerns with this procedure that they're asking the court to adopt. As to As to the assertion that this is simply too confusing to the jurors, the court will instruct the jury on what the law is. And as we've argued on these other motions, the court can't just start with the assumption that jurors aren't going to follow the law, that it's simply too concerning or too confusing for the jurors. The jurors will receive instructions. They are presumed to follow those instructions as a matter of law, and the court should assume that these jurors will do as they're instructed. And unless the court has any questions for me, that's all I have. Thank you, Your Honor.
Last bite at the apple here from Jay.
Well, for the record, it really wasn't that confusing. We had the propensity aggravator in that case. We put on evidence that pushed back against that at that point in the case. It's cleaner from
Anne's not looking
jury's
at it.
perspective. It was cleaner from our perspective. I don't think we even argued about it. I think the state just went along with it. And I thought it went pretty well.
How'd it go for your client?
And I definitely want to push back on the idea that, we have a tendency to have these tautologies in the law where we say, well, the jury is great and they'll figure it all out. And so long as we tell them what to do, then they've done what they were told. And there are studies that show that's just not accurate. I mean, there's the jury project. You can read what it's like for people to go through these things. And when we're talking about whether or not somebody's going to be put to death, I think it's important that we, really think hard about how these people are going to make these decisions. If we're going to do a normal, just a penalty session, I definitely think it's something that's going to require some additional instructions. I know the Supreme Court just recently updated a lot of the ICGs, which is great, something that I've been advocating for. But there are additional things that I think are going to have to be told to a jury so that they can understand how that would function. And if you trifurcate it, it's going to make it simpler for them to understand, okay, you've now found this person guilty. Now you're going to be determining whether or not one of these statutory factors exists. This is what they are. This is how they're defined. You have to find this beyond a reasonable doubt. The state's going to do an opening statement and a closing. They'll put on evidence as to whether or not these things exist. This defense is going to come in, question those things, put on their case why those statutory aggravators don't exist, and you're going to make that determination. If you make that determination, then we get to a sentencing proceeding where the state's going to be able to put on any additional aggravators that it wants to put on, and the defense can then put on any other information that they have.
The judge is thinking about his summer house up in McCall.
It works, and it worked, regardless of whether or not the SAPD doesn't agree with me. I'd ask the court to consider it. Certainly if the court decides not to do it, we'll have lots more conversations about how best to do that.
It's an intriguing idea. The concern, of course, is the desire to do this case once and not twice. And there's a protocol that has been approved by the appellate bodies versus the one that you're proposing now. And so that's always in a trial judges who tend to be fairly risk averse difficulty.
Yes, sir.
That was funny.
Well,
it's like we could do it your way, but I'd rather just do it once and not have to redo the court after the appellate court
dance
holds
sheet
up.
indicates that we have covered all the topics. Did I miss anything from either of your perspectives?
Not from the state, Your Honor.
No motions, Your Honor, but I think Ms. Massa has one thing.
One housekeeping.
Sure.
So housekeeping, scheduling maybe?
Judge, we submitted Professor Cover's PowerPoint and her data. We filed it this morning under seal. We had a conversation that you thought that should probably not be under seal, definitely with the PowerPoint. We have no issues there. It was filed with one thumb drive. We discussed letting us look to see if there is victim information that needs to be redacted. So what I'd like your permission to do is file an amended Exhibit A, and if we'll get things redacted. The one that's filed and you are inclined not to seal, I just don't want it to get out there before we've had an opportunity to review that and redact names.
Okay. I'm assuming the state doesn't have an objection to that.
No objection, Your Honor. Thank you.
All right, and that's fine, counsel. Let me address, that brings up a good point in terms of just process for filing matters that need to be sealed in some way or the other. Because as we know, the rules for filing require them to be physically filed if you're seeking to have them filed under seal, which causes some difficulty for most of you who are not in the Treasure Valley area. I think perhaps the best way to deal with this is if you're going to file something and there's some portion that needs to be under seal, if you would provide a redacted and an unredacted copy. So for example, I think the defense filed a recent request for discovery and had an exhibit attached that they felt should be sealed. I'm assuming that's why they requested it to be sealed, was because of the exhibit. So you would file that one with the exhibit just being a blank page saying redacted, and then provide the court and opposing counsel a courtesy copy of the unredacted, and then you can file the unredacted when you are here to get it filed under seal. And then we can let the public have the redacted version so that we, as much information as we can make public, we can.
We'll do it that way. Thank you.
That works for everybody.
Thank you, Your Honor.
Else for today?
Nothing else for today. There was a motion filed that got placed under seal that the court was going to schedule.
Is that about your jury voir dire procedure? Yeah, I think that's probably more appropriate to take up as we get closer to the pretrial than anything, because it really deals with
he calls it voir dire.
Essentially what is and isn't allowed in voir dire and in questioning. So I think it's just a little early in the game yet to get to that, from my perspective at least.
Your Honor, the only thought I have about that is perhaps talking about that may cause the court to think we should begin voir dire maybe a tiny bit earlier than is currently scheduled.
Well, we can, I think our pretrial is in May, correct?
I don't recall.
I think it's in
trust the
May.
court on that.
And our voir dire is set to begin in August or late July, I can't remember. So I think we have some flexibility there, and perhaps we'll address it at another hearing before the pretrial. I just thought with the number of motions we had today that it was probably something we could save for a later day.
Fair enough. Thank you.
State, anything from you?
Anything else?
No, thank you, Your Honor.
So that I'm clear on the record with respect to why I sealed that, I don't think you submitted that intending it to be sealed originally. The reason I did is because it had in there specific questions that can and can't be asked of folks who are being questioned for voir dire. And because of the extensive publicity here, I don't want to unnecessarily limit our available groups of veneermen because they've read something about what questions to specifically expect to be asked. And so that was my reason for sealing that. Okay. All right. Well, thank you. Everybody have safe travels back. I will take the matters under advisement and issue written opinions forthwith. Thank you.
Forthwith. We're going to find out what forthwith means for this judge. Let's see bails. Our court watcher there in green holding that blue binder. Thank you very much for that. Court will be beginning soon. I think court just ended. I'm almost positive court just ended. Long hearing, unproductive on the defense's front. I would say it was no bueno. It was no bueno for them. They threw a lot of things at the fan. They threw a lot on the wall, and it didn't stick. It didn't check out.
Call from Angela.
Angela, how are you doing?
I'm doing good. Procrastinating, doing some stuff, but this was worth procrastination.
We might have a court watcher calling in, so we might have to cut you off, but go ahead.
Yeah. I just realized something. I thought the Jolly Arias was my first trial that I watched, although after, not live, but afterwards. Mm-hmm. But when this defense lawyer mentioned international law, something popped up in my head. I watched international court back in the day, although not willingly, not at the time at least. My grandpa did watch it.
You were forced to watch court?
Well, we had only
terrible.
one TV, and it was pretty much everyone watched. But that's not the point. It was international court, where this international law came from, that mentioned. And that's why I am calling in. And I can't go, because of the theme of these channels, I'm not going to go into what exactly I watched with my grandpa and what was the case is. Mm-hmm. But this, but it has to do with pickles and not politics.
Right.
Yeah, that's the thing. So
it gets political.
It has, yeah. So this international law regarding death penalty has to do, what I remember, it's those cases. I don't know if there was even a death penalty on the table. It was international court, not any state court or country court. But if it was meant, as I remember, it was meant for those kind of cases that are on the international level, crimes against people, so that's what, it's not hard to not go into politics, but you know what I mean, what this intended for,
Yeah. I think the argument...
But I still don't remember, I watched 2 or 3 international trials, I don't remember, and I still don't remember death penalty being on the table in those trials. They may have deserved it, but I don't remember that being on the table. And I don't know why, but yeah, and this international law is only for international courts. It's not even located in the U.S. It's located in the Netherlands.
Yeah, I would
say the U.S. has...
I would say that the argument about the international law falls flat on its face because pretty much throughout the United States, there's a strong, we are our own. We have our own law. We're not like, we're going to have our law underneath international law. We just do our own thing. And so when the defense gets up there and says, we think that the 8th amendment should take guidance from international law, or that the international law should oversee how the 8th amendment is applied. Nope. That's a big no way. Lots of pushback there, and the judge is like, yeah, that's not going to happen. That's just not how it works here. But
here comes the huge but. There is this thing that you can actually go to the international court and sue the state. I don't know if you as a person can sue the U.S. because I think U.S. has some more system, they can't be brought in international court. Don't ask me the details because I don't understand them. But I know the details because there was a case here in Sweden where someone has been wrongfully convicted and been in jail for 20 or so years. And when, I want money because I was wrongfully convicted, blah, blah, blah. And Sweden being a little, no, we don't want to pay you, blah, blah, And he was like, okay, I'm going to international law. They wrote the check quicker than he was in 5 minutes, So I don't know, it depends. I don't know how U.S., because I heard that they are not accepting international, what's the name, court in Hague. Someone said, yes, I'm talking about the Hague. So it's a tricky one,
Yeah, it is tricky. Angela, thank you very much.
Yeah.
You're breaking up quite a bit. So before the phone goblins eat the rest of the conversation, we're going to say goodbye and thank you for calling. I appreciate it.
Yeah, you're welcome. Bye.
All right. See you. Bye-bye. All right. I'm still trying to figure out why my camera is deciding back and forth how it wants to be. But we'll get that figured out. Let's see. Yeah, everyone who's had problems with buffering has come back later and said, "Oh, I refreshed and it went away." I've been monitoring my stream on my end for quite a while, just checking to see what's happening, and it's good on this end. Dynamic adjustment setting on the camera. I'm looking at it. I think I've got it locked down pretty good, but let's see if we switch. Let's see if you guys can see a difference here. Oops, we don't want to go there. Let's go to camera 4. Let's turn this off for a minute. Hey, you're going to be on screen in just a second, bud, if you don't move. Okay, so if I switch the camera to high detail, is that better? Now it's a much higher. It's very crisp. It was fine. No change on your side. Okay. Looks the same to me. I saw a slight change, but if you guys didn't see one, that's great. See and hear you fine in Scotland. Thank you. Can you summarize this hearing for me? I can, Ivy. It went down like this. The Bryan Kohberger's team spent most of today trying to fight. Now I turned the lights off. It's got to be auto white balancing. I'll adjust the setting and get that fixed. But Bryan Kohberger's team spent most of today trying to fight the death penalty and to get it off the table before the jury has a chance to select that for Bryan Kohberger if they choose that he is, if they vote and say that he is and find him guilty. This is very premature in a lot of areas, but if they can win this argument here and say, look, for whatever the reason, whether it be, look, Idaho can't buy the drugs to make death penalty happen. The injection drugs, they won't sell them to us when they know we're going to use them for death penalty. So because of that, we can't do that. We can't use the firing squad because we tried that, then we took it off the books, then we brought it back. We don't even have a firing squad set up. So you can't use that one either. For all the reasons about the aggravating factors, that's not fair. It's against the Constitution because juries, when they're told these aggravating factors, they convict more often than not. For whatever reason it was, and they probably had 12 different reasons today for why they should get rid of the death penalty. They wanted to get rid of it ahead of the trial, so it was not an option before things started. And most of those fell on their face. Everything that the judge responded to today, the defense lost, and there are indications that they pretty much lost everything else as well, and there will be a written ruling that way. Defense seemed pretty deflated towards the end of it, even with the Mr. J coming in at the end. His half-hearted attempt at his last few arguments, he basically had said, look, I admit that Supreme Court goes against this, precedent goes against this, so you're not even able to rule the way we would like. But I'm just doing this to preserve the record because we think that the previous 2 Supreme Court decisions on this fact were wrong. It is the definition of a losing argument in court. There is no way he's going to win those. But they had to do it. It does preserve the record for down the road when they want to appeal and say, look, we've been arguing this from the get-go. And, you never know. maybe Kohberger is going to be the case that the Supreme Court takes up and says, you know what, we reverse our decision. That's what they're hoping for. But lots of effort was spent today to eliminate the death penalty as an option, to make it so that they didn't even seat a jury and get them qualified as a death penalty jury. Every way you can possibly envision them to take death penalty off the table, they tried today, and I think they failed on every front. And I think Anne knew it. Towards the end, she was pretty much consigned to the fact that this was a waste of the day in many ways. You pick a jury based on how some feel about death penalty. Some do not believe it, and others will not give a death penalty even if he's found guilty. Yes, in the voir dire, as he says, in that process, the jury gets asked questions specific to a death penalty to see if they would be able to choose this. AWOL. I can tell you one thing we're not going to do, and that's not a poll, because he's innocent unless proven guilty. What's in your mind, my friend?
That was a rhetorical question. I just wanted to see who was going to respond to that. Yeah. I know you can't, because I think he's innocent regardless of it until he is proven guilty.
I should say unless proven guilty.
A little bit of satire.
Yep.
But I just want to say this with the death penalty. I'm not concerned with the matters of this case or not. I'm not doing pickles. I mean, I'm not doing politics here. This is all pickles. And you know me, I love my thought experiments. Mm-hmm. This is a thought experiment, my folks, and I'll hang up. What if an innocent person gets the death penalty and he is 100% innocent? Just the state proved it in a certain way, but we know that he was innocent. If that is a possibility, because there were innocent people put to death after death were exonerated. It's too late now. You can't reverse that. The life is now gone. Yeah. If he was given life, right, and his case was appealed or new evidence came, if he had life, yes, he was in there for 30, 40, 50 years, but he gets to come home now.
Well, you can't reverse that either. You can't give someone that 30, 40 years of their life back.
No, you cannot. And that's another issue I have. But at least he's alive. But you can have remedies to fix that problem that he did the 40 years, which is another thing that I don't want to digress into the system.
So, you know how I like tech, right? I like technology.
Yes.
I think technology will answer this problem for us. All we have to do is when we convict somebody and find them guilty, we just enter them in cryo-freeze. And then, if they're guilty, we just keep them there and just never thaw them out. And if for some reason we got it wrong, we just bring them back. It's like, hey, just kidding, sorry. There you go.
That didn't work for Walt Disney, so allegedly. So we don't know yet. I just think death penalty is too permanent for a potential, as if the state doesn't lie. Because if we all sat here and watched the Cameron Reed trial as a community together, and let's admit that we were disgusted with the solo cups, right? And we were like, there is no way that we could find Cameron Reed guilty on how they handled their investigation. But yet in the same breath, some people will turn around and say, give BK the death penalty. How is that even a thing? What if the state did Cameron Reed tactics? We don't know yet because the trial hasn't happened. So that is just my point. So thought experiment. If an innocent person can get put to death, should we still have the death penalty? And my answer would be no, due to that fact.
I would say by extension, we can't have any punishment then.
What do you mean? No, we have to have punishment. No, we're talking about death as a finality.
Some people would rather die than be in jail, right? It's worse for them to be locked up for the rest of their life. It's terrible. It's torture for them. Give me the death penalty instead of locking me up all day. But in your mind, you think that's better than the death penalty. I would say that if there's a chance of getting it wrong, and that is our main concern, that if there's a chance we're wrong, we don't do it, then that ties our hands on all punishment.
I don't know about all punishment. I get your point. I do. You know what? That's another good point. Because then at what level do we attribute 10 years, 20 years, 30 years, 40 years for the crime? But there is law for that. I just think that the finality, but if you were convicted and went through all your appeals, right? And then you were still found guilty and you have to serve your 80, I'm sorry, if you're innocent, you had your chance. And that's how the system works. You can't win all the time.
And same with the death
right?
penalty,
But
right?
I just don't, it's just the death penalty aspect of
They have more appeals as a death penalty. They have more appeals that route than a citizen, than somebody who's just incarcerated.
Correct. It's just the fact that at least I know that there's more than one person in history that was innocent, put to death and exonerated. And that just doesn't sit right with me. Whether it's pseudoscience, bite mark testimony, blood splatter, body language.
You need the firearm tool markings in there as well. Hey, well, I've got to let you go. I've got another call coming in. Thank you, my friend. We'll see you.
Just a thought experiment. All right, you're the best, man.
Thanks, man. Bye.
Peace.
Call.
Denise. That was Denise. That was our court watcher. Denise, I'm going to call you back because I can. Hold on. Call Denise.
Hello.
Hello, Denise. This is RA. I just missed your call.
Hey. That's okay. Are you still live?
We are live. We're waiting anxiously for you to come and report on what it was like sitting 5 feet from Bryan Kohberger through the entire hearing.
Like literally. Yeah. So it's definitely an experience. He's not nearly as large as people think he is. As a matter of fact, in some of my little notes this morning, I was mentioning how he seems to, his suit jacket almost looks too big. Like maybe he's losing some weight.
Mm-hmm. So that anxiety about the possible death penalty.
Y'all, I cannot keep a straight face to save my life in that courtroom. That's why I sit where I am, because it's like, you're on camera. People can see you. Yeah. Don't show your feelings. But I got to meet the Gonsalves, and got to give them a hug. So that was nice.
So was there a lot of victim family representation there today?
There was a lot. In the morning session, there were probably, in my notes, I wrote 6+. In the afternoon, I think a couple people decided not to come back. I think they knew it was going to be a short afternoon, so they decided not to come back.
Were you expecting a bigger finish in the afternoon than we got? It seemed like a dud.
I was expecting a much bigger finish. But I mean, it is what it is. I am not surprised that Judge Hippler said he was going to take it under advisement. Just because it was so much, but he's not gonna. He doesn't buy it.
I agree.
He's not buying. He's not buying what they're selling.
At one point, he even went so far as to tell Jay, the last lawyer, that his argument went over like a lead balloon, about as good as he thought it would. You know, he's like, either in front of me or in front of the Supreme Court, it would have the same effect.
Yes.
It's like, wah, 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 wah. It was funny. There's probably 3 times throughout the day that he gave that type of response, with that being the strongest one at the end. But
so it was definitely not as big a finish as I had expected it to be. I'm not sure exactly what I expected. We did have some spicy moments in the gallery, and I've got pictures to prove it. So I will be posting, like literal pictures to prove it. it was all over a lady who is actually a fan of the defendant.
A fan club?
Something. She thinks this whole case is bogus and that the whole thing is going to get dismissed.
Well,
so there's
that.
So there's that. She flew in from Chicago for this hearing, but she does sketches, and so there was spiciness in the gallery over her and her sketches. But once court was over and we were outside, she allowed me to take pictures of her sketches that were absolutely her legal right to do.
Is it safe to share just a brief overview of what they might contain?
It's just pictures of the courtroom. It's her sketches of the. Hang on a second.
These are like character sketches, like you go, New York on the street, and there's some guy who will sketch you. It's like with a huge head and a funny look. Was it like that, or was it like a
No, but that
chalk
would have
drawing?
been amazing. No, but that would have been amazing. Sorry for that pause. I'm sitting in my car with the windows down because it's 50 degrees and I'm sweating. And Ann Taylor walked by, so I needed to pause for a moment.
Did you give her your condolences on the day? No?
No. I just smiled and nodded. She knows.
Yeah. You sat right almost on her lap for most of this.
Yeah.
Or she was on your lap. I think you were behind.
Yeah.
Tell me about the actual attendance.
As far as the general public goes?
Yeah. This is going to be the courtroom we presume that the trial's going to be in, right?
I hope not. If this is the courtroom that the trial is going to be in, it is very, very small. It is the same courtroom we were in for the last hearing. The max capacity is like, I'll have to go back and look at my notes from the first hearing, but I want to say it's less than 70. There are at least 2 other courtrooms in this courthouse that are twice that size.
Man, we might need one of those because you're going to get a lot more people like that lady who are drawing pictures in court.
Absolutely.
And
yes, absolutely. We're going to get a lot more. But the sketches that she did one of like the overall courtroom. She did one with, what just kind of looks like stick figures sitting at the defense table and the jury chairs. She sketched Ann Taylor and then the other female attorney. I can't say her name. Mastis.
Well, I'm excited to see the pictures.
Yeah, I'm excited to share. I actually passed her a note this morning when I first noticed that she was actually sketching, and asked her if she would share them with me after court today, and she told me maybe. So I was glad to see them.
And she's there supporting Bryan Kohberger, right?
Mm-hmm. Yeah.
Did you have a chance to talk to her about maybe her reasons or what her...
No.
Okay.
No. So the lady that was sitting next to me today, she's a local, and she took the day off work just like I did to be here today for this. And so she and I, just kind of started chatting and everything. And then this other lady from Chicago, and this was all outside in the 27, 28 degree weather this morning waiting for court to open. She's spouted off and said something about how bogus this whole thing is, and that the whole case is going to get dismissed. And I just kind of stepped back and didn't say anything, and those two started going at it, and I just kind of stepped back up and got between them, and I was like, y'all, let's not do this here.
Easy now. Wow.
Easy now. Back down.
That is crazy. We have months to go before this goes to trial. There are obviously going to be a lot more hearings, a lot more, a lot of them are going to be sealed. Especially as we start sorting out how the jury selection is going to work and everything else. But we're past the deadline for discovery. We should be all done with that. But apparently some more is still coming in. So we'll keep watching the docket for more. I mean, there were so many things filed in the last month alone.
I know.
It's going to be wild.
And it's all on Discord.
Yep. Thank you, Debbie. Appreciate it. It's going to be sorry, Denise. I called you Debbie. Denise. I'm like, that didn't sound right. Denise. I corrected it before you did, so it was like I didn't make the mistake. Denise, thank you very much. Appreciate you. I was reading chat, and I think there was a Debbie in there. But that's
okay.
You've done a wonderful job. We look forward to having you watch some more court for us and fill us in on the details as we're moving forward. But thank you very much.
Yeah, you're welcome.
And I'll watch for those pictures.
I am going to head home. Probably take me about an hour. If I go straight home, it would take me about an hour, so not too bad.
Is there a chance? Sorry, I'm reading texts and asking you questions. Is there a chance you'd be able to share those pictures on either Discord or Facebook?
Both, absolutely.
Okay, wonderful. I know a lot of people are curious as well. So.
Oh, yeah. I put everything in both places because I know that we've got people that don't do Facebook and we have people that don't do Discord. So yeah, I will get them shared out later on this evening.
Sounds good.
My honey is cooking dinner, so I have nothing better to do.
Awesome. Denise, thank you so much. Loved seeing you there on that front row, so appreciate you.
Well, hopefully, as much as it pains me to sit right there, I at least know everybody can see me, and that I need to keep my face in line.
I didn't see you ever out of line. There's no reason the judge kick you out of court. You did a great job. I saw you were taking a lot of notes, flipping the pages and going, so that was good.
Yeah. So, all right. Well, y'all have a good evening, and I will be back in touch.
Thanks, Denise. Drive safe. We'll see you.
All right. Thanks.
Bye.
Bye.
Awesome. Denise did a great job. She was wearing green, carrying the blue binder, just behind Ann and Bryan during the entire proceedings today. So great coverage. Looking forward to those pictures. Obviously, if you want to see the pictures, you might want to join on the Facebook page. If you do, remember, you have to answer the questions on the join. If you just say join and don't answer the questions, you'll be denied. There are too many bots. We have to sort out the bots from the real people. So on the Facebook side, you can join that way, and we'll try to get you approved as quick as possible. Also, over on Discord, on the As the Gavel Drops Discord page, we'll have those as well. So either way, it would be a great place to go and see that. So thank you, Denise. All right, I have to get into my camera settings and fix this auto white balance adjustment, or auto, I'm not sure what it is, auto iris. It's driving me nuts, the fact that it's flipping back and forth. So, Mrs. R.A. can't pass the bot test. At this point, I'm not certain that I'm human. Oh, that's good. I can vouch for you. You're human. You're human. Let's see. There are some other, some great, no spoilers, please, but there's some other breaking news in other cases right now. I'm gonna let you guys watch that as you choose, so I don't want to spoil it or have anyone else spoil verdicts. I know we've tried to delete those as much as possible here. Tonight we also do have the podcast coming up. Yes, at 8 p.m. tonight, which I think I'll actually do a portal to, where you can just ring the bell and go be informed when it happens. There we go. We're set up. Portal's created. Podcast tonight, we are giving away free memberships. If for some reason you have not received one thus far, make sure your settings turned on and then show up bright and early for the podcast. We'll be giving those away as well as having some more fun. Thomas and I will be back after a 1-week hiatus for Halloween. So excited about that as well. All right. Alarm set for podcast. Thank you, Lois. It's funny we have to prove to a bot that we're not bots. You found the irony of the situation. It's actually manually selected, so I read them myself and approve them myself sometimes. Thank you, Red Pen. Appreciate it. Had a very interesting day. Had some good words today. Gubernatorial. Love that word. Gubernatorial moratorium. The two together, that's like winning the lottery. It was a lot of fun. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again tonight with the podcast at 8 p.m. I'll have time to prepare, Thomas. I'll have time to prepare. It's going to be awesome. We'll see you guys there. Have a good night, everybody. Bye-bye. Eight people just asked to be on Facebook. We got 8 invitations. I'm reviewing them now. Francis didn't answer the questions. Sorry. Melissa didn't answer the questions. Lael Astrid didn't answer the questions. All right. We'll try again. You guys have a good night. We'll see you.